Oh, after many twists, turns and court dramas, the Senzo Meyiwa murder trial resuming this morning. But there's been a lot of changes, especially for accused numbers 1 to 4. And I now understand, Slindelo Masikane at the North Gauteng High Court as well, that those accused 1 to 4 no longer want to be represented by advocate Malesela Teffo. I'm sure you'll understand and forgive us if it's a very difficult court case to follow. What's the latest we have? What are we expecting?
Good morning, Gareth. Of course, we find ourselves outside the North Gauteng High Court, where in about 2 hours we are expecting the resumption of the Meyiwa murder trial, where there are 5 men accused of his death. But of course, we know that there have been many dramatic scenes inside as well as outside of court, many of which have had some kind of implications in terms of the slow pace of the movement of this particular trial. What we are expecting this morning, of course, is that there is a letter that was addressed to the defense for the accused in terms of the eNCA now clarifying its position in terms of docket 375. That is the second docket in this case, which alleges that those in the house have a case to answer to, and that there were no intruders, in fact, on the night at which Meyiwa was killed. Gareth, I want to bring in a legal expert at this point. We're joined by Marius du Toit via Zoom, who's just going to give us some context in terms of the implications of this particular letter. Good morning, Mr. du Toit. Maybe if you could just give our viewers a sense as to this letter in terms of the jurisdiction. Good morning. This letter in terms of the jurisdiction of docket 375 being moved from Johannesburg to Pretoria. What exactly then is the eNCA trying to do in terms of getting that docket into the very same jurisdiction as this particular trial?
Well, I think, Slindelo, it might just be a matter of convenience for them to move it to Pretoria, keeping in mind that the Johannesburg and Pretoria High Courts basically have concurrent jurisdiction. So one and the same jurisdiction would apply. So I don't think it's anything that would have a difficulty for the state at the end of the day. And I think it's just that this court, or the Director of Public Prosecutions Pretoria, has been seized with this matter because the prosecution is currently being done in Pretoria. And I just think that they want the same DPP to maybe make a decision on this docket, because after all, the prosecutor dealing with the trial presently would be in the best position to say at the end of the day, listen, I want to prosecute individuals in the other docket. But let me just remind you, Slindelo, and just say it's never advisable to separate the trial like this. You normally want all the accused to be tried together. And the reason for that being is if one accused implicates the other, it makes it always easier to have that in one trial, because then the court could say, well, listen, the fact that you are implicating one another, of course, makes it easy for us to make a verdict. But when you separate trials, that makes it very difficult, because now all the witnesses have to testify afresh in the second trial should the state decide to prosecute. So it's not advisable. It is what we have, and we can just hope that the matter proceeds today.
Mr. du Toit, of course, a lot of concerns around the slow pace of the movement of this trial. We know that if proceedings don't resume officially with the cross-examination of the state's first witness, that there's a possibility that the defense for accused 1 to 4 will then apply for a separation of the trials. What kind of then implications would this have for this particular trial?
Normally, a separation will be ordered when one of the accused plead guilty and the rest of them plead not guilty. To order a separation of trials for the other accused where witnesses have testified will not really be granted. I can't see that happening in this trial. But what I do see happening is there's this new attorney or advocate representing 1 to 4 might say, listen, I've not had enough time. You know, we're waiting for the transcript of the record to be made available. And only once I've perused that, we've been in a position to proceed. So the question remains whether he has, in fact, been placed in possession of a transcript of the proceedings, and whether he is, in fact, in a position to proceed, having regard to the fact that Teffo is now, not going to be involved in the trial any further. And the other attorney, of course, who said, listen, I have had the opportunity of now perusing docket 375. Well, we'd expect that person to be ready to proceed at least, because they've been involved in the trial since day one. It's just a new advocate or attorney coming in that might have some difficulty proceeding.
Lastly then, Mr. Dutoy, speak to me about the fact that the NPA has decided to go with a forensic officer as their first witness, as opposed to calling those who were in the house. We know we've heard from at least the attorney or the lawyer for Kelly Khumalo, who is insisting that her clients and those in the house should be the ones that are called to the witness box next.
So, Slindelo, we have to always remember that the state prosecutor is dominus litis. That means he's in charge of the proceedings. He decides who goes first, who is called to testify first. And normally there's a lot of planning in that. You know, as a prosecutor, you always want to start well and you want to finish well. So you want to call one of your strongest witnesses maybe when you start the trial, and maybe towards the end, before you close your case, you would want another good witness to maybe end it off. And in the middle, you'll insert the rest of the evidence, which might be forensic, ballistics, or pathology witnesses testifying. So to start off with a ballistic or forensic expert, there's nothing untoward about that. It might be just a matter of convenience for the prosecutor. It might mean that this witness might be engaged in other courts, and they just quickly want to help him away so that he can go to another court. So I don't think you can read anything into that per se. And having regard to the fact that the prosecutor who's seized with the matter has to prove the evidence beyond a reasonable doubt. So he bears the onus. He has to make sure that by the time he closes the case, there's a prima facie case that demands an answer from the accused, because you want the accused to be put on their version, to go into the witness box and to testify ultimately.
Thank you so much for your time this morning. That is Mr. Marius Dutoy, legal expert. Gareth, just giving us some context as to what we can expect this morning. Of course, that's a letter that's going to be handed up by the NPA clarifying its position on docket 375. And of course, we are expecting proceedings then to resume at around 10 a.m. this morning. But what we are also expecting possibly is the fact that Kelly Khumalo's lawyer says that she's also going to make an application to be allowed back into court. You would remember that she's on a watch brief for Kelly Khumalo, and in the beginning stages of the trial was asked to leave because of the concerns about her presence possibly tainting the trial by the defense for accused 124. So we will be bringing you those live visuals of the trial resuming at 10 a.m. this morning on DSTV 403.
Yeah, I'm quite looking forward to it as well. Also regular updates from Slee on Twitter as well as to what's happening, because it's a very confusing court case. But hopefully today we get it underway again and get some clarity. Just to remind you, this start of the trial, only one witness has taken the stand. That was all the way back in April.